Hello, everyone. My name is Robin Long. I'm a partner in Denton's Vancouver office and a member of the firm's corporate group. I, along with Leanne Krawchuk, co-lead our Canadian mining group. In that capacity, I'm very pleased to welcome you to our four-part series, Digging Deeper, the latest trends in mining from Canada, Latin America, and the Caribbean. For some time, Canadian-based mining companies have held interests in Latin America and the Caribbean. From our perspective here in Canada, mining-related opportunities appear abundant in various regions, but it's clear that companies in the sector also need to be aware of investment risks, including changes to laws and shifting political landscapes. In connecting with our global partners from Latin America and the Caribbean, we thought it'd be useful to discuss some of these issues. As a result, we've created a four-part webinar series to address questions that we've been asked in our respective practices. In the series, we will cover mining disputes, ESG considerations, investment opportunities, political landscapes, business structures, and tax planning in the key jurisdictions of Latin America and the Caribbean. In our first session, we'll be discussing mining-related disputes. Our speakers will give an introduction to the mining landscape in Colombia, Chile, Bolivia, Ecuador, and Canada before moving on to discuss risk factors, dispute trends, and considerations for structuring mining-related investments. I will now pass it on to Hernan Rodriguez, partner in Denton's Colombia office, to start us off.
Thank you to everyone for joining us today. I'm Hernan Rodriguez. I'm partner in the Denton's office, the Denton's Bogota office in Colombia. And today I'm joined by my colleagues, Enrique Benitez from Chile, Jorge Inchauste from Bolivia, Leire Suarez from Ecuador, Rachel Howie from Canada, and myself from Colombia. Let me present briefly my colleagues for you. Enrique Benitez, as I told you, is a partner of co-leading Denton's Chile's Energy and Natural Resources departments. Enrique has more than 25 years of experience advising Chilean and foreign clients in the materialization of their mining projects in Chile. He has advised its clients in a wide range of corporate, regulatory, environmental, permitting, and community relations, among others. And he also has a strong practice in litigation related to mining projects, whether before civil, administrative, and environmental courts, and in cross-border mining projects built between Chile and Argentina, as the Pascualama project of Barrick. He is the vice president of the Chilean French Chamber of Commerce and is a member of the board of several companies. Leire Suarez from Ecuador is the director of the dispute resolution team, and she specializes in complex litigation in administrative, commercial, labor, and civil liability matters, as well as domestic and international arbitration. In the field of arbitration, Leire has advised numerous clients in domestic arbitration proceeding in the mining, oil, construction, and entertainment sectors. In international arbitration, she has experience as local counsel in commercial and investment arbitration under ICC, UNCITRAL, and ICSID rules. Currently, the firm is advising clients in several confidential arbitration in private contractual disputes relating to mining royalties and transfer of mining concessions. Leire is admitted to practice in Ecuador and the state of New York and has been recognized by major legal directories as a dispute resolution associate to watch. Jorge from Bolivia, Jorge Inchauste, has been a partner at Denton's Guevara and Gutierrez since 2002. He has been in charge of structuring the developments and finance of projects and investments in various matters concerning natural resources, including important mining projects. In such a capacity, he has also advised in several mining disputes, including litigation or arbitration proceedings between private entities concerning joint ventures, investment, and finance agreements, representing clients in disputes with the Bolivian mining regulator, and successfully acting as Bolivian counsel in international investment arbitration proceedings for foreign investors against the Bolivian government. Let's go with Rachel Howie from Canada. She's based in Calgary, and she serves as the deputy co-lead for the National Canadian Litigation and Dispute Resolution Group and co-lead for the country's ADR and arbitration group. Her practice focuses on international arbitration along with domestic arbitration and litigation in the mining and resources sectors. She regularly acts for mining companies involved in disputes locally in Canada and around the world. Last, for me, as I told you, I'm Hernan Rodriguez. I joined the firm as a partner in 2017. I am the co-head of the Natural Resources Group and have participated in some of the most important hydrocarbon, oil and gas, mining, and infrastructure projects in Colombia, including ports, railways, and oil refineries. And I have also been actively involved in mergers and acquisition transactions, especially in the mining and oil and gas industries. I am the legal consultant of most of the mining companies that are active in Colombia, and as a member of the steering committee of the Colombian Mining Association, I have actively participated in all the latest regulations for the mining industry, including social and environmental matters. Well, so in today's webinar, we will provide a summary of the trends in mining disputes in Latin America and Canada. And before we get started, a few notes for you to cover. Please, if you have any questions that you would like us to ask any questions that you would like us to answer, please ask the panel. That you would like us to ask the panel, please feel free to submit them throughout the session via the Q&A function, and we'll do our best to address them. You can also reach out to any of us directly if we're unable to get your questions. Our contact information is on the PPT slides. Please note that the presentation is being recorded and will be made available with the PPT presentation in the post-event. And you can also go to our website, intentons.com. So before I pass it to my colleagues, I will start. I will speak a little bit about Colombia. So please. Perfect. That's perfect. So some general information about Colombia. Colombia is the third largest population in Latin America. We have around 50 million people. We also have the fourth largest GDP in Latin America with around 271 billion. And we are located strategically. We have two oceans and we have three main mountain ranges of Los Andes, as you can see in the map. Colombia was also ranked fourth in the Doing Business Index, LATAM Doing Business Index that was issued by the World Bank. Next, a little bit about our Colombian mining industry. So within the adoption of the new mining code of Colombia in 2001 and the implementation of some tougher security policies by the national government since 2002, the Colombian mining industry saw significant development and growth. In the recent years, we have continued and Colombia has kept growing. For example, from 2014 to 2019, mining GDP increased in over 35%. 2020 has been the best year, for example, for gold mining since 2016, and exports of this metal amounted to almost $3,000 million, and the production rose to 1.7 million ounces. All of that despite the pandemic. And the foreign direct investment in mining also increased from 2015 to 2019, when it amounted to over $1,500 million. Due to the pandemic, this trend stagnated in 2020 a little bit. However, the sector expects 15% of growth in 2021. Since 2018, the contribution of mining in Colombia's GDP has increased to more than half a point, and more than $11,000 million have been contributed in taxes and royalties from 2010 to 2020. According to a 2020 annual survey of the mining companies that you know by the Fraser Institute, Colombia ranks first as a country in the Investment Attractiveness and Best Mineral Practices Index in Latin America and the Caribbean. We say as a country because as a region, Salta in Argentina is the first one. Correct? So next. So Colombia for sure is a key player in Latin America. Some additional information: we're first in coal and emeralds, we're fourth in ferronickel, and sixth in copper and gold. And we are the third country in Latin America to implement an international grade standard for the report of mineral resources and reserves of exploration works. Down you can see other figures. In any case, you will receive the presentation that we have on other numbers on coal, gold, salt, emeralds, nickel, silver, platinum, etc. Next. A country to explore. You know, even though we try to be a mining country and we have had a lot of mining after 2002, we have only around 7,000 mining titles, and that's like 3.5 million hectares, which is only 2.9% of the territory. So only 2.9% of the territory is under active mining titles in Colombia, and of this, only 10% correspond to projects in the exploration phase. So sure, we're on an unexplored country, which makes us like a very good task for an opportunity where there's a lot of opportunities in Colombia. because we have a great potential. So in the map, you can see there's a lot of the territory that's not being covered yet with mining titles, because of other challenges that you will see that we will discuss a little bit later. Next. So the main challenges of the mining industry, well, given that now we have mining, we also have a lot of challenges. And basically the main challenges are first, the environmental and zoning matters. We are a very biodiverse country. And that means that in the last years, a lot of protected areas have been declared, such as natural parks, moorlands, forestry reserves. But the problem is that a lot of these natural reserves and protected areas have been declared when there are mining titles already granted in those areas. And of course, this is a source of conflict. That's a challenge. The other challenge is community. We have kind of the ethnical communities, in which we have a lot of challenges, and we have also the non-ethnical communities, in which we have challenges too. The ethnical communities, actually, there's kind of lack of clarity on the provisions regarding the rights of the ethnical communities, and that makes that, for example, a previous consultation process, which is required before initiating a mining project or an extraction project, it's very difficult to close, so you never know when you have to consult again. And we also have informal mining. You know, Colombia is a poor country, and like given that it has a lot of potential, then we have a lot of criminal mining for one side, and in the other side we have traditional miners which actually live of the mining. And so it has been very difficult for the government to cross a line between these two, and it has been very difficult to actually to fight this informal mining in Colombia. And last, there's legal certainty. You know, in Colombia, the mining authority is a party to the contracts, and it ends being also a judge. So we have a lot of conflicts regarding, for example, interpretation of the royalty clauses within the contracts, which I will explain a little bit later. Next. Said this, then we have disputes in the mining sector, which is actually the topic of our webinar, in which we have internal ones and external ones. Given the first challenge of environmental and protected areas, we have had some judgments, very important judgments in Colombia, in which basically they declare the areas. There are mainly judgments from the Constitutional Court, and they have been very clear in saying that even if you have a mining title, you don't have an acquired right. So actually, even if you have a mining title, even if you have an environmental license, whenever a moorland or a natural park is declared, then the environment will have the priority, and then you have some problems there. So that is a source of conflicts as well. In connection with the communities, as I just told you, all the things that have to do with ethnical communities, and whenever they have the right, whenever they have to declare which is the territory of these communities, has been also a source of conflict. In the illegal mining, there's one very important now from Sandor Capital, which is always also Gran Colombia, against the illegal miners, in which the court has given some status to the illegal miners, which can become problematic. And regarding what we call the legal uncertainties are the conflicts because of the interpretation of the royalty clauses in the different contracts. When we go to external and investment arbitration, I'm going to list them in the next slide, but I can tell you about Ecuador, Galway, and Red Eagle. They have basically the same claim against the Colombian state because of the moorland of Santurban, which was declared in Santander after these companies had already their mining titles there. The one that's more advanced is Ecuador, and there was a very interesting judgment in which basically the court said, look, there's no expropriation here because the environmental will always have the priority. However, Ecuador has to be compensated and indemnified. So we are waiting to see what is the formula that they are going to bring in order to calculate those indemnifications, and that would be very important for the future proceedings. We don't have until now really international arbitration regarding the ethnical communities, but we do have one very important, in which sentences have been very important, which is the one that of Gran Colombia versus the Republic of Colombia, in which actually Gran Colombia is arguing that the government has not made any effort in order to ban and to prohibit illegal mining in the areas in which Gran Colombia has their mining titles. And last, we also have the problem regarding the interpretation of the royalty clauses, in which actually sometimes the companies have even agreed with the mining authority to some modifications to the royalty clauses, but the Comptroller Office, which is the one in charge of taking care of the state money, has said that these clauses are illegal. So next. So in terms of investors' protection, well, it's important to mention that Colombia is a party to 18 free trade agreements with 66 countries. It also has 12 double taxation agreements. And under the investment protection offered by the free trade agreements, several mining companies have raised claims against Colombia in connection to the aforementioned challenges for the mining industry. So before 2016, there were no cases in Colombia. After 2000, because actually there was no mining and all the mining was in early stages. After 2016, we have a lot of cases. And I already mentioned some of them, but there are actually Glencore, Cosigo, Ecuador, Red Eagle, Galway, Gran Colombia, Cerro Matoso, and last, Anglo American PLC. So next, please. So basically, as conclusions, Colombia is an attractive jurisdiction for investors, no doubt about that. And it actually ranked first in the Investment and Attractiveness and Best Mineral Practice Index in Latin America and the Caribbean. But of course, the progress of the mining industry in Colombia has come with new legal challenges, which I already explained. And many of these legal challenges have resulted in domestic and international disputes within the framework of investment arbitration. So the case law derived from these disputes will be key for Colombia to overcome its legal challenges. So thank you very much. Thank you so much. And then please, I'll give the word to Enrique Benitez from Chile. Please, Enrique.
Thank you, Nan. Thank you for the introduction. And first, I would like to thank the organizers of this webinar for inviting me for participating today and addressing you about the latest trends in litigation in Chile. Next slide, please. Well, Chile is a mining country. As you will read under the yellow circle, the mining sector in Chile is one of the pillars of Chile's economy, and copper exports alone stands for more than 1/3 of government income. This through our state-owned copper production company, which is Codelco, is the largest copper producer in the world. And this results in mining account for 10% of our GDP. Some statistics about Chile. Well, Chile covers an area of a little bit more than 291,000 square miles and stretches over almost 2,700 miles north to south. So we are a very thin and long country. In our country, you find all kind of geography. In the north, we have the desert where all the mines, or most of the mines, are located. In that desert, that desert is the driest desert in the world. You can find the driest point in the world. It has not rained for the last 100 years. But we also in the south have a kind of a geography more related to the rainforest, much similar to one that exists in Canada or in Europe. Our population is a little bit higher than 18 million. Our GDP, although it has decreased in regard to the 2019 GDP, is nowadays to the 2020 GDP is of a little bit higher, of almost 252 billion. It's the fourth largest in South America, and our GDP per capita is almost $15,000 per capita, which is the highest in South America. So at least from the numbers point of view, we would say that Chile's inhabitants are the richest in South America. Regarding our trade balance, it's quite stable, being China and the United States the most important trade partners for both imports and export. In regard to exports, they are our best customers regarding mining products. So and also we acquire from them a lot of the machinery that is needed in the mining industry. As said before, the mining sector in Chile is one of the pillars of Chile's economy, and copper export alone stands for more than 1/3 of the government. Already in 1870, Chile positioned itself as #1 exporter of copper in the world. And still today, Chile is the world's largest producer of copper. But it also is the largest producer iodine and rhenium. It's the second largest producer of lithium and molybdenum in the world, the sixth largest producer of silver, and the seventh largest producer of salt. Regarding gold, for example, I think we're in the place number 13th in the world. So that shows that we are a mining country at the end. Another figure that shows that we are principally a mining country is that 8% of the world metal explorations are carried out in Chile. Last year's explorations were carried out in Chile. Next slide, please. Are risks to the industry? Yes, they are. The first one is related to the constitutional reform. Due to a social unrest that started in October 2019, triggered by an increase of subway fare, very similar to what happened in France with the Gilets jaunes, which sparked massive protests and riots all along the country. Our current president, President Piñera, agreed to a referendum on rewriting the constitution. More than a reform, it's a rewriting. And just for your knowledge, the referendum was won by the approval alternative for the rewrite of the constitution by more than 80%. The Constitutional Assembly was just elected about 2 months ago, and they have just started work in the rewriting. But we still don't know much about what will be the what will come out of this assembly. But nevertheless, there is some concern that the constitutional reform may change the economic fundamentals and political landscape that has allowed much of the economic progress Chile has made over the past 3 decades. Some voices we are hearing as saying again or talking again about the nationalization of the mining projects, the nationalization of water, and all that could, affect the mining projects at the end. Another risk is related to the greater empowerment of local communities and NGOs. The major conflicts, I should say first that in general, we don't see much conflicts and litigations regarding mining projects in Chile. But in the last year, we have seen every year more of this. And there are major conflicts in which the mining companies have been involved are mainly linked to environmental impacts, territorial dispute, human rights violation, and well as lack of compliance with the corporate social responsibility policies. All this triggered by the local communities and the NGO mainly. We have 3 examples of this. The first one is a Pascualama project owned by Barrick Gold. This is a cross-border project, gold project, 20% located in Argentina and 80% in Chile. The project started all the environmental assessment in 2000. They obtained the approval by 2010, more or less. But the opponents to this project were very successful in building a negative speech against Pascualama. So when in 2014 they failed in the compliance of an environmental obligation related to non-contact water system, the authority was very pressured and finally gave in, applying a fine of more than $15 million and stopping the project. That fine was the largest ever applied until that time in Chile. So it marked a before and after in what regards to fines related to environmental issues. Another important issue here is that at the time, Barrick already had invested in the project $4 billion. So it's not a small investment or a small project. Another case is the Codelco tailings in Chañaral. Codelco is a state-owned company, although Chañaral is a coast city located in the north. And Codelco has 2 big mining projects near to the city, not very near, about 150 kilometers from the city, but the tailings are located on the coast, just beside the city of Chañaral. For 40 years, they didn't have any problem, no social concerns, nothing. But for a few years ago, the local communities started to organize and oppose Codelco for having these tailings and asking the authority to oblige Codelco to submit a new environmental assessment for the approval of the operation of these tailings. And at the end, the Supreme Court ordered that Codelco had to submit this environmental assessment, and they are in that process right now. And the last one is related to Cerro Colorado of BHP Billiton. This is a project located near Santiago. And the Supreme Court decided last week that they will only be able to continue with operations as far as they submit a kind of water system used for the project within that period. So if they don't submit that, they will have to stop production. Another issue or important risk is related to the reform to the water code. The proposal here seeks to establish the essential right to water, given legal security to exercise of human right of access to drinking water and sanitation, and reaffirm the nature of water as a national asset of public use. Likewise, one of its goals is to establish new regulations for the concession, use, and suspension of water rights, and to provide protection for preservation of inland ecosystems. Due to this, and although already happened, it's not something new, but with this, it confirms that in the future, mining project will not be able to continue using natural water. So they will have to think in exploiting their projects through desaled water. The problem is that we're once again, hearing some voices saying that the desaled water should also be declared as a national asset of public use. If that happens, that will mean that in case the human right of access to drinking water is not complied, well, the supply of water to the mining project could be stopped in order to give that supply to the inhabitants of any town or city in Chile. Another risk is the new environmental institution and legislations. Environmental courts and superintendency of the environment were created not long ago, and since then there is a great and strict control over environmental issues, especially over cases of environmental damages in which the authorities are seeking for environmental responsibility of companies. Nowadays, you could also seek for criminal responsibility of some companies, depending on the non-compliance obligation that is related. And also they are seeking for some responsibility in case of water contamination, which is something that happens quite often in regard to mining projects. And last but not last, there is a new mining royalty under discussion in the Congress. We already have a royalty, but this one is very different. And it's very different because it's based on gross sales or in the amount of mineral extracted. This meaning that the companies will have to pay a royalty regardless of the results, which is not what happened with the current royalty, which is related to the results of the company. So this is a risk also. Next slides, please. Well, how is this driving litigation? First of all, I must say that not litigation, but judicial procedures are very related to the origin of the mining projects, because mining property in Chile are granted through a court. So a judicial procedure not always is a litigation because you not always have an opponent, but it could come litigation if an opponent opposed to the constitution of your mining right. Same thing happens with the constitution of easements. In general terms, in Chile, mining easements are granted through also a judicial procedure. As I said before, we don't have many litigations related or big litigations related to mining projects in Chile. Nevertheless, we are seeing every time more of them. We foresee, and in the future, we foresee an increase in environmental litigation initiated by the respective authorities for the purpose of enforcing environmental obligations, seeking for environmental responsibility from companies, as I said, even criminal responsibility, and in relation to issues related to access to water and its contamination. From another point of view, and regarding we foresee also more international litigation. And this is due to that every day there is a greater opposition to mining projects from local communities, which initiates litigations both in Chile and abroad, like the Inter-American Court of Human Rights, in order to try to stop these projects. And also, and depending on how the constitutional reform process and or the regulation of the new royalty ends, we foresee that could probably trigger an increase in litigation by mining investors, in this case, before foreign courts seeking for compensation from the Chilean government. Next slide, please. So, well, thank you. That's my presentation. And I pass the word to Jorge Rinchazo, my partner in Dentos, Bolivia.
Thank you very much. And it's a great pleasure to speak with all of you. my presentation is going to be about Bolivia and the trends that we have there, which I'm sure some of you may find quite as interesting as I do. As most of you know, Bolivia is right in the middle of South America. We like to call it the heart of South America because we're right between Brazil, Paraguay, Argentina to the south, Chile and Peru to the west. So right in the center of it all, we have very many good and close neighbors nearby. And we are right at the top of the Andes, and the territory goes all the way into the Amazon basin. As a result of that, Bolivia is blessed with many natural resources. And the Bolivian economy is based particularly on the extraction and exportation of minerals and natural gas. 50% approximately due to natural gas exportation, mostly to Brazil and Argentina, and between 35 to 40% of the GDP based on the international price of minerals from exporting traditional minerals that are produced in Bolivia. So these traditional minerals are mostly tin, silver, copper, iron, and gold. It is said that with all the silver that has been exploited from the Potosi region of Bolivia, we could have built a silver bridge all the way to Europe. Of course, that can never be proven. The fact of the matter is that we still have a lot of these traditional iron, gold, and silver production going on in the southern west part of the country. Aside from the traditional minerals, the Salar de Uyuni, or the Uyuni Salt Flats, are not only a natural wonder, but also one of the world's biggest reserves of potassium and lithium. It's also a very beautiful place to go and to see some out-of-the-world sceneries and sites. So I do recommend visiting, if you can, this beautiful place in the world. Currently, with so much interest in the development of batteries for electric powered cars and all sorts of electronic equipment, there's huge interest in the development of the lithium reserves and the potassium and all the other non-metallic, non-traditional minerals that are housed there and in other salt lakes in that region. And right now, the Bolivian government is carrying out bidding processes to invite very many different companies and countries to propose bids for the development of the huge reserves in the salt flats that we have in the country. The Mutun is also a huge iron ore deposit in the eastern part of the country, very close to Brazil. It is among the largest iron ore deposits and has been a hot topic for a long time. It gave rise to some litigation between the Bolivian government and Jindal Steel from India as a result of a mining dispute regarding the development of that iron ore deposit. But we expect that will be something that will promise to give more investments and development. So if we could go to the next slide. One of the main points that currently is on the mind of most mining investors in Bolivia are the regulatory changes, the intervention that is going on, and the litigation that is entailing, mostly with the administrative authorities of the government. So in 2014, we changed the Bolivian law, that changing the concessions-based system to an administrative mining contract system, right? This special transitory authorizations that I described farther down. This change limits a lot of the rights that miners had with the concessions in the past, and it gives them mining contracts that have more restrictions and requirements. Of course, this change has led to further regulatory intervention by the AHAM, which is the mining authority in Bolivia, It's like a supervisory authority that controls and may revoke the mining rights that some miners have as a result of different infractions of law. And this, of course, has led to many cases reaching or exhausting the administrative procedure, and in some cases going to the Bolivian Supreme Court. Fortunately, most of those cases have been resolved favorably in our experience, and the mining companies have been able to revoke the administrative resolutions that resolved their rights, and were able to maintain their rights and continue their exploration and exploitation activities in all sorts of different areas, right? Comibol, on the other hand, is the Bolivian government-owned mining company, right? It was formed after the first wave of nationalizations in Bolivia in the 1950s, after the Bolivian Revolution. And it still holds to this day very important mines, areas, and that are very interesting for the development of different projects. This has led to many successful joint venture agreements with foreign investors, even from the 80s till today. And these are still a great source of opportunity of investment by entering into agreements with Comibol, whereby Comibol puts forward the mining rights, if one would like, and the foreign investor is able to develop and produce those areas. And of course, this has also resulted in some litigation with the government's own company, but has not. Most of those cases have been resolved favorably. The next slide, sorry, we discussed something that is very important, which is the investment treaty arbitration and the nationalizations that have occurred in Bolivia. From 2006, under the socialist government that entered Bolivia with Evo Morales first and now Luis Arce Catacora, Bolivia nationalized or expropriated many companies that were privatized during the 90s. As a result of that, a huge wave of investor state arbitrations were initiated under the ICSID and other international arbitration mechanisms. This led as a backlash that the government denounced the Washington Treaty on the ICSID Convention, and also led to the termination of all the BITs that Bolivia had subscribed during the 90s, right? Notwithstanding, as a result of long sunset clauses, many of them with 10 years of duration, many of those rights for international investors are still available. And that has led to arbitrations that we have also participated in. I note two relevant ones that we were involved in. One is Kiborax versus Bolivia, that is a result of the expropriation of mining concessions in 2004, and reached a final award on September of 2015, more than 10 years later, but granted the investor $48 million of indemnization. That was settled later for $42 million. South American Silver is another example that claimed against the government of Bolivia in 2012 and was awarded an award of $28.7 million in November of 2018. It was later settled for 25, but that is just two of the cases that we participated in, and that we have been successfully able to aid investors when they've come into tough situations with the Bolivian government. Currently, the new mining law requires that Bolivia be the seat for any arbitrations. And there are still some agreements that the Bolivian government has entered into that allow for arbitration, international arbitration, but that require Bolivia as the seat of arbitration and have some other requirements. For our last slide, if we can go, is we're going to talk about other private litigations that have been that we've been discussed. The first one is what I've been discussing, basically the the fact of being able to take many of the administrative resolutions to the Bolivian Supreme Court on appeals, and being able, we note that at that level we've been able to obtain a better resolution. International arbitration and domestic litigation have also resulted from contracts among private parties, right? Be it for the provision of or the offtake of the minerals, or a joint venture agreements for the development of different parties. Finally, something that is also that in our practice and that we've seen quite a bit are constitutional claims, amparo constitucionales, that are available in different countries, whereby investors can claim and miners can claim the respect of their rights under the Constitution. So those are some of the things that are currently most active in Bolivia. I would like to hand it over to Leire Suarez from our office in Ecuador, who can talk a little bit more about that region.
Thank you, Jorge. As you mentioned, Bolivia is considered the heart of Latin America. Well, Ecuador is known as the belly button of the world. Ecuador is betting on investment, development of the mining industry. Currently, mining investment represents a great increase in the past year. Products from mining represent 5.93% of all Ecuador's exportation, and it became the fourth product behind oil, bananas, plantain, and shrimp. In the last year, the exportation of mining products has grown 127% compared to the year 2020. In sum, mining is becoming the most important industry to help Ecuador overcome the current economic crisis. As you can see in the map, there are several important and strategic projects: Loma Larga, San Carlos, Rio Blanco, Cascabel, Cangrejos, Curipamba, La Plata, Yumiragua, and Ruta de Cobre, among many others. As the map shows, there are only few provinces in Ecuador that has been exploiting or exploring mining concessions, and there's a lot more to explore, the same as in Colombia. Also, the NAMI, and state-owned mining company, is looking for investment in 4 projects, 3 non-metallic projects and 1 metallic project. Next slide, please. What about the risk? Mining, as all industry, has some ESG risks. In relation to the environment, this is a highly regulated industry, but there have not been any cases against mining corporations. However, this may come, as you know, in oil industry, there's the infamous case of Chevron. And also, Ecuador is known in international litigation and arbitration as the first country to raise environmental counterclaim in an oil-related case initiated by the investors Perenco and Burlington against Ecuador. So we are expecting to see other environmental cases, and there's always the risk of a claim if the proper environmental plans are not followed. In relation to social risk, the same as in Colombia, we have the prior consultation. What is the prior consultation in Ecuador? All the mining projects that will be developed in indigenous community territories needs to have a prior approval. Also, we have some experience in community interference, as I will later mention in the case of Copper Mesa, and also protest against mining projects. In political risk, the first thing you have to know about Ecuador is that, the same as in Bolivia, we have no bilateral investment treaties. we have terminated all of those treaties, and therefore all the protection from the investment comes from local law. And as you know, local laws are changing all the time. Additionally, and in relation to social risks, in our constitution, we have a mechanism of direct democracy that is called the referendum. And in February this year, there was a referendum in Cuenca, the third most important city in Ecuador, which banned the mining activity in certain areas of high risk of water resources. This referendum does not affect already ongoing mining process, but may prevent future projects from development. However, there's still a lot of possibility to invest in Ecuador, and we can help you subject to a good due diligence. Next slide, please. But don't be scared, there are some good news. First of all, we are back to ICSID. Also, Ecuador is, the new government is enacting new laws to attract investment. For example, the regulation to the Arbitration Act was enacted a few weeks ago. This regulation provides for more freedom and makes it easier to solve disputes through arbitration with the state and state entities. Also, this regulation clarifies and makes simple to enforce international arbitration awards in Ecuador. In relation to the political risk mentioned before, it may be reduced with investment contracts that provide stability clauses and where parties may agree to arbitrate disputes to ICSID or other firms. Also, there's absolute freedom to provide for arbitration in private contracts, and administrative contracts may also include international arbitration as long as they have the approval of the Attorney General. Next slide, please. In relation to arbitration to litigation trends, as you know, Ecuador is one of the most sued countries in investment arbitration. We hope to change that reputation. However, in relation to mining, we have not had many cases. The only finished case was Copper Mesa, a Canadian company, against Ecuador. The claim was raised by an illegal termination of the governmental mining concession in Ecuador, in Junín, Chauca, Atelimbela. However, this case is considered in arbitration as a tie. Why? Because the investor claimed over $69 million and the tribunal awarded only $19.4 million. Why? Because the tribunal considered that the investor contributed in a 30% to the damage caused to its investment. And how did Copper Mesa contributed? Well, the tribunal found that Copper Mesa acted violently against the community, or at least some people acted on behalf of the corporation against the community, and therefore reduced the compensation in 30%. Another case, a more recent case, is the one initiated by Codelco. As Enrique mentioned, Codelco is a Chilean state-owned company, the biggest company exploiting copper. Codelco filed the notice of arbitration just this year, arguing that Ecuador and the state-owned company Enami breached the agreement previously reached by the parties by failing to create the company that will develop the project in Jumiragua, and also breach the shareholders agreement. We do not have much more information about this case because it's just beginning and it's a recent case, and all the information for now is kept confidential. Next slide, please. What about Canada? Traditionally, most of all mining investment have come from Canada, and because of the arbitration centers and its experience in mining, it has become a place to choose as an alternative forum seat. We have suggested clients in the past to choose Canada as the seat of arbitration in private contract, As you know, Copper Mesa is Canadian. When dealing with governmental entities, it is also possible to include international arbitration in the exploitation contract. Our experience in private arbitration is very good with Canada as a seat. For example, in the case Chaparral Gold versus Janfield, a commercial arbitration between a Canadian company and a Chinese corporation for a breach of a SPA contract that has a seat as Canada, the Chinese company refused to pay the price for the concession, for the mining concession, arguing that the Canadian corporation did not disclose that under Ecuadorian law, the corporation with shareholders in a tax haven was not able to own mining concessions. However, the tribunal found against the Chinese corporation and ordered to pay the price in the SPA contract. We are expecting mining to continue rising, more exploration, more exploitation, more investment, and more projects. We expect to see less dispute against the state for violation of investor protection standard, since the government is trying to attract investment rather than to create disputes. However, as the industry grows and develops, we expect to see more private dispute due to this new investment, maybe some environmental administrative cases. For this purpose, we have a qualified team to assist an investor in negotiating and drafting both private and administrative contract, including arbitration clauses that set a proper forum for dispute. And we are able to coordinate with other offices, as you have seen, around the world in Dentons to provide for a comprehensive advice in this cross-border transaction. Thank you very much. I will pass now to Rachel.
Hello, everyone. I am the last speaker on our program today, and this means that I've had the pleasure to hear from my colleagues on the trends and developments impacting mining disputes and mining in their jurisdictions. Many of the matters that they have canvassed and discussed also resonate for Canada. Rather than repeat what we've already heard, I will attempt to tie these comments together and present them for Canadian mining companies with respects to dispute trends and risk management. I propose to do this because Canada, as we all know, is an exporter of mining expertise and investment. While we are the corporate home to many mining companies, those companies routinely operate in other jurisdictions around the world. This makes developments in other countries important, and I'm going to speak to trends from this international perspective. I will comment briefly on 3 trends that are increasingly important for Canadian mining companies from a disputes perspective. If we could please go to the next slide. These trends are expansion in resources and locations, and increase in disputes generally, and also ESG, environmental, social, and corporate governance. On the first trend with respect to expansion, we heard about this in Bolivia. And for those in Canada, we are also continuing to see a trend toward expansion in 2 ways. First is an expansion in the types of minerals and resources that mining companies are pursuing and developing. An example here are the many projects that we are now seeing that are seeking to explore and develop lithium, along with those projects looking for rare earth metals. Second, as a result of that expansion into new minerals, along with advanced technologies and exploration savvy, there is an expansion with respect to the areas being pursued for mining. These advances in technology have allowed previously uneconomic areas to be developed for more traditional minerals. In addition, companies look to mine newer and different minerals, such as rare earth metals. They are sometimes looking in new and different jurisdictions for jurisdictions or regions for operations that typically haven't been the source for mining exploration and development. This trend is important, and it relates to disputes because anything new carries with it the possibility for disagreement. in particular for the mining sector, where there are so many overlapping interests and regulatory mechanisms. This leads to the second trend, which is an increase in disputes, both investor-state disputes and international commercial arbitration. We've already heard from my colleagues on investor-state disputes in certain countries in Latin America. And mining operations, by their nature, because they are capital intensive and long-term, typically do give rise to a number of investor-state disputes that we see at any given point in time. Miners are on the forefront of expansion and development, and they sometimes start to have operations in areas that the regulatory system has yet to catch up to, or that is impacted when the regulatory system looks to change. This can happen in new physical areas for exploration where there is not currently a robust regulatory system, and the local government then looks to implement those regulations. It can also happen with respect to new minerals that might not be subject to existing regulations. Companies looking to expand into new minerals and new areas, as well as those already operating in the mining industry, should consider undertaking an investment structuring review and analysis at the outset. This is particularly the case for companies that are embarking upon a brand new project. Knowing from the beginning whether your investment has the benefit of an investment treaty can help to mitigate risk. Investment treaties typically provide protections against expropriation. They will provide protection against discriminatory treatment, typically also for full protection and security, and frequently contain provisions to protect against the free movement and transfer of capital in and out of the jurisdiction. We have seen in a few areas or situations where a new mineral is discovered for Canadian mining companies, they look to explore that mineral, expand on development, and then there can frequently be political pressure after the fact to stop the foreign exploration or to regulate in respect of that mineral and development. Investment structuring can assist if there ever were regulatory steps taken in that regard. And if we can go to the next slide quickly, we can see how the situation works for those who aren't familiar with it. It is an area that can be very easy to get right, and also an area that can be very easy to get wrong. If we look on the slide on the screen, we have a Canadian investor looking to invest or implement a project in country A without any direct bilateral investment treaty or other type of treaty with investment protections. There is no investment protection in that situation. And we heard that this can be the case in Bolivia and in Ecuador. If we change the situation slightly and have that investor make the investment through a subsidiary in another country where there is a bilateral investment treaty with the ultimate destination country, that can give rise to the investor investment protection that that company would be looking for. And if we go back to the previous slide, please, the protection of an investment treaty, or if there is no investment treaty possible, an appropriate contractual clause can assist from the risk management perspective, because the option of a dispute, or in particular investor-state arbitration, can carry significant negotiation weight. It can carry with it the potential to head off and resolve a dispute. If that's not possible, it also then provides the company with options outside of local courts in international arbitration, where protections are based in the treaty. One final point on investor-state disputes: having an appropriate structure or contractual protection in place can also assist the company in pursuing its rights. If structured correctly, a mining company can potentially tap into dispute funding for a claim, and that would allow the company to recover some of its losses while moving the prosecution of its claim more or less off book. This is a fascinating area, and it also opens up options in an M&A context where one of the entities involved has disputes risk. Of course, that would be an entirely separate segment all onto its own. So I will leave that topic for now and go back to international commercial arbitration. We have already heard from my colleagues on private contractual disputes, and I'm pleased to hear that people have had pleasant experiences in Canada, because of course here we are seeing a trend in growth in arbitrations in the mining sector with the Canadian connection. Canada has extremely sophisticated international arbitration practitioners, arbitrators, and venues for hearings. To the extent that local court assistance is required for those international arbitrations seated in Canada, our courts are independent and familiar with the arbitration process. One trend that I will highlight in this area that is very important to keep in mind when drafting agreements or looking to amend or revise existing agreements is the expansion of options under international arbitration rules. There are many options for dispute resolution and arbitration clauses in contracts. This is also an area that can be very easy to get right or very easy to get wrong. And unfortunately, a poorly drafted clause can sometimes have substantial impacts on the process for a dispute and substantially increase cost and time to get to a decision. So for this reason, it is, as we heard from Lyra, very important to consider advice on dispute resolution and arbitration clauses. What worked in the past might not necessarily work in the future. And so it's important to give some thought to what it is that you're actually looking for in a process and the types of disputes that might come about. The third and final trend that I will touch on, we've already heard on as well, and that's ESG, environmental, social, and corporate governance. This is an area that can require many assessments for a Canadian company. There are, of course, local obligations under Canadian law and securities requirements if the company is domiciled here. There are then also obligations in the jurisdiction in which the company operates. And in some cases, these obligations might extend to entities with which your company is partnering in ventures or doing business. The regulatory landscape here, of course, is quickly developing and fluid, and failure to abide by obligations imposed either by public authorities or through contract can have detrimental impacts. As we heard from Lyra, the situation of a potential counterclaim on ESG matters is also a quickly developing area. As ESG regulations develop, we are seeing a growing number of investment arbitrations where a challenge, a defense or a counterclaim by the state is a failure by the company to abide by local environmental laws. This is somewhat related to situations where there is a misunderstanding in the local environmental law that allegedly leads to the defense or the counterclaim. But it is a very real risk and underscores the importance of getting local advice throughout and at every stage of a project. In addition to those public obligations, there might also be the potential for these ESG obligations to play into private contracts and through companies with which one is partnering. So it is important to also keep in mind that as the situation relating to ESG develops, there might be an increasing number of obligations from the private side to be aware of. For Canadian companies, there is also an interesting question now that's been left open by our courts on the degree to which Canadian companies could have local liability for alleged violations of customary international law, specifically where that is claimed to impact the ethical behavior of a company, or there is a local issue in that regard alleged against the company. As I said, this is an open and unsettled issue, and what it does is bring those potential international matters and goings on front and center in the Canadian court system. In order to best manage risk in light of this increasing awareness and changing environment, again, it's best to get that local advice in all jurisdictions in which your operation is impacted on ESG regulatory requirements, and then of course on the disputes side to best try and alleviate risk. I think unless we have any questions, which we'll be monitoring for, those were the comments that I had with respect to Canada and trends that we're seeing with respect to mining disputes and that companies should be aware of.
Well, thank you very much to all. I think it was very interesting. And so I'll pass it now to Robin, please.
Thank you for participating today. We hope you can join the members of our mining team for the next topic in our series. If we are unable to get to your questions today, please reach out to one of our team members by accessing the contact information set out in the PowerPoint. To get the latest updates and our views on matters affecting the mining industry in Canada, you can subscribe to our Mining Law Canada blog by visiting our website at dentons.com and clicking on our Insights page and accessing our blogs and resources. On our blog page, all you need to do is just scroll down to the bottom of the page and click Stay in Touch. And enjoy the rest of your day.